Okay, I'd like to call to order the special meeting of the Planning Commission for October 22nd, 7 p.m. Members present are Jim Vigliotti, Harold Watson, John Staley, and Daniel Senft, and alternate Sandra Zalik is also here. The first thing, because it's a special meeting, we cannot approve the minutes from September 17th. We'll do that at the next regularly scheduled meeting. So the next thing is zoning referrals. And we have a text amendment from the Zoning Commission to revise number 12 regarding parking requirements for various uses. And I believe we've been discussing this for a few meetings now. And it's mainly changes to the, like health clubs and gyms, automotive services, schools, convenient markets, food store. Am I correct? Those are the ones we're
Madam Chair,
concentrating.
may I ask a question about that? Is it, if I look at the primary document, section 12, it seems like all of this text is already existing. We only make one revision early in the text. There's a cross out and a rewrite, 12.5.3. And then we add all of these others that don't currently have any distinctions in
Correct.
our current, okay. And these are basically most everything that we had discussed in previous meetings.
I believe so. I don't think there's any changes. I didn't see any. Were there any?
When this document was in color, it was very easy to see. I didn't realize that, it's hard to make any, it's hard to identify what the changes were. But when you look at 12.5.3, for example, if you read the narrative that follows in the summary, for residential offices or home occupations, the recommendation is 2 visitor spaces per unit. So in 12.5.3, we already put the 2 spaces and removed the 3.
Right.
And rewrote the whole thing. Oh, all right.
Okay. Any other comments?
Well, I went back through all of our notes and all of our previous documents, the ones I could find, and the only thing that we're really leaving up in the air still, the other ones we've really thoroughly discussed. We did stop at the high schools, but I think since the Stratford High School parking lot's already been determined, we have no real need to worry about it. We have existing parking lots at all of our schools. We're not going to gain any more parking spaces or build anything on them right now. So I say
Probably
that
not.
we just leave that as it is. I assume the town will work closely with any of our schools if suddenly they need more parking.
Well, based on the occupancies right now of the 2 high schools, they're about 1,000. They average about 1,000 students. So if you take it 2 per every seat, it's 500 spaces. Half of the student body does not drive, obviously. So, the 500 spaces, I would think, should be sufficient along with the teachers. But it might be actually, you might look at it as being more than we need, but you have also special events that go on at the schools. But you're also correct, but if ever they were to do any changes or to, say, Bunnell High School, which needs it pretty badly, this may come up. So, yeah, it seems like it should be a moot point, but in a way it's not, because that down the road, that may be a school that we need to renovate.
But my assumption is that the school will be a friendly actor with the town in this, so we needn't worry about any kind of litigation or whatever.
I would hope so. But I think even at 2 per space, which is the same as one of the towns has, Milford. I think, we'd be safe, in my opinion. The elementary school might be a little bit much in that it's about 500 actually, I think it averages 400 kids in most of the high schools. Divided by 3 is about 134 spaces. Obviously, none of those kids drive. So you're only really talking about teachers. That might be a little bit much, but they also might have, like Johnson Academy I'm thinking of, they have the auditorium. So, that, and they do put on plays. So, it might actually work out well, but 133 or 34 spaces for Nichols, that's a lot of spaces.
If I may add, but as a parent of a child myself, of 2 children actually, one in middle, one in elementary, I can tell you the school's parking lot gets pretty full when there are parent-teacher conferences, when there are, events, like she said. And during those circumstances, no matter how much parking is available, parents still park on the streets everywhere that they can find a spot in the neighborhood. But having said that, there should be a right balance between how much we provide for parking and how much they utilize. And based on comparative examples, I think, we still reduced it when we did discuss it last time. For the elementary, we thought it was 3 spaces per seat, and for high school, we came down to 2. And it is all subjective, like when somebody brings an application and we think that nobody would say we would need less parking. It's pretty rare that somebody would say that. But if they do, and if our Complete Streets picks up, then definitely that's something to think about and amend the regulation. But right now, we have nothing. And not having anything is like you're giving an opportunity to the developer to decide whether to provide enough or not. And I wouldn't do that.
Although the developer would be the town.
Yes.
In this case.
In this case,
Yeah.
yes.
In only this case. So it is a balancing act of, are we going maybe a little bit too much for, say, a Nichols school, but not enough for a Johnson Academy, because of the different facility. And that, on a case-by-case basis, probably could be worked out. But at least there's a guideline to give, the town in this case some guidance. Mr. Saley.
And this will also, can be changed down the road if things change.
True.
And see how it works.
Any other comments?
I just want to comment that we are following the guidelines of the POCD, that they've been recommending we do this, and that now is 5 years. So I think we should move this forward as quickly as we can.
I agree. Can I have a motion then? Mr. Vigliotti.
I'd like to make a motion to send this to the zoning commission with a favorable recommendation.
A second? Mr. Senft, saw that hand. Any further discussion? Hearing none, all in favor say aye.
Aye.
Anybody opposed? Hearing none, that passes unanimously. The next one is the Planning Commission text amendment that we've sent over to, I thought we sent it to zoning, but maybe we just sent it to the staff.
It was sent,
Zoning too?
it is sent to zoning. They're going to review it this month.
So do we have to do anything?
Well, you can send a recommendation, whether you're in favor or not.
Oh, I thought we did. Okay.
No, we didn't.
Okay. Any discussion on the electronic signs at West Broad and Paradise Green?
This is your baby.
Mr. Staley? Yeah.
I think we are advancing in a great way, and we should move forward with this.
Very good. And I think, if I recall, we had some information from, was it from you or Jay?
Jay.
saying that this is also consistent with several objectives of the Plan of Conservation and Development.
Yes. Jay wrote that for zoning commission. Yeah, he's the staff for the zoning.
Right, and he recommended approval as well, so.
Mhm.
Mr. Staley?
Just one last comment, hopefully. These signs are also available for the town during emergencies.
Yes.
And this is a part of our emergency preparedness when something comes about, be it weather or whatever. And it's a great asset for the public. Thank you.
I agree. If there's no further discussion, is there a motion? Mr. Vigliotti?
I'd like to make a motion to send this to zoning with a favorable recommendation.
Sorry.
Mr. Staley will second it, thank you. No further discussion, hearing none, all in favor say aye.
Aye.
Anybody opposed? Okay, got that done. At least that's off our agenda. Thank you very much for that. And now we're going to Ersted Biddle Incorporated to replace section 1.8 regarding the definition for building height. And I guess Mr. Knott is here for that. Thank you.
Good evening, I'm Barry Knott. I'm a lawyer at 1656 Main Street, Stratford, and I'm here this evening on behalf of Ersted Biddle Properties that owns the Dock Shopping Center. The application shows up as being an application by me for the zone text amendment. That I was acting on behalf of Ersted Biddle when I submitted that zone text amendment. But I've handed you exhibits that I want to briefly make reference to, and I want to make reference to them with respect to the administrative comments that Jay made that are addressed to Richie Fredette on the Zoning Commission and dated October 15th. Did you get copies of those administrative comments?
Yes.
Okay. So he takes you through the town plan of conservation and development. The bottom of the first page, it is consistent with land use and zoning. The top of the second page, let me back up a minute, just tell you what the amendment has to do. It has to do with building height. And it has, in Ersted Biddle's particular case, it has to do with the building height of the self-storage facility that we got approved by the Zoning Commission 3 or 4 months ago, right behind the Starbucks and the Chipotle restaurants, okay? That building is 60 feet high, which is what is allowed in a light industrial zone. Lo and behold, as it turns out after the fact, there's elevator shaft and HVAC equipment that stick up 3 or 4 feet beyond the 60th foot, okay? So I have a situation where I have gotten approval for a non-conforming building, so height-wise. So I talked to Jay about it, and many municipalities allow slight increases in building height to cover equipment, such as HVAC equipment, elevator shafts, and that kind of stuff. The issue is, you don't want that stuff to be visible from a street. You want it to be covered so that it's not an eyesore to the public. And in this particular case, this building is the first thing that you see when you come over the Washington Bridge on the right. And this is the building that's got the big Welcome to Stratford sign on it. So, in any event, I talked to Jay about the zone text amendment, and this first one that I've highlighted in yellow is the zone text amendment that I submitted. That's the one that's officially submitted. And you can see I've outlined the new language, which talks about a maximum of 5 feet provided that the equipment is shielded from streets or highways, okay? Now, if you look at Jay's administrative comments on the second page, he says the second issue is to simplify zoning code to increase its usefulness and understandability. He says that this regulation is inconsistent with that objective. I don't necessarily agree with that. That's kind of a subjective opinion on his part. Give him the benefit of the doubt, and we'll say that it's inconsistent, okay? The third and the fourth, this proposed amendment is consistent. So as far as the plan of conservation and development is concerned, we got 3 out of 4 consistent and 1 inconsistent. But the real issue has to do with the middle of the last paragraph, second to last paragraph there, which I've highlighted in yellow. And he says, it's unclear how this will look in residential applications. For example, if someone decided to put mechanical equipment on the roof of a single-family dwelling, they could do so and exceed the 30-foot height max as long as it's screened. When considering how this might impact single-family zone design aesthetics and rooftop projections across all zones, the proposed amendment would appear to require some more comprehensive thought. And that comment, in my opinion, is a stretch of the conceivable possibilities that will happen vis-a-vis this type of equipment. Because there aren't going to be any elevator shafts in single-family residences. The air conditioning compressors are usually put in the yard. But once again, we'll give Jay the benefit of the doubt and say, yeah, I did not think of residential houses when I wrote this amendment, and I didn't. I wrote it for... So what I did in the second handout that's got the red on it, I provided an exception, I provided a limitation on this zone text amendment so that it would apply only to limited business districts, only to retail commercial districts, only to waterfront business districts, only to heavy commercial districts, only to coastal and light industrial districts, and only to general industrial districts. Those are all of the commercial and industrial districts in the town of Stratford. That list right there. That's them all. I got them all there. So with this modification to my zone text amendment, this relief that I'm seeking only applies to commercial and industrial properties. It does not apply to residential properties whatsoever. So that answers Jay's issue. And the last one that's got no coloring on it is simply the second one without the red lining on it, okay? So we've got the original that's got yellow, the second one which I've amended to exclude residential, and the third one which is a clean version of the second one. So we're prepared to modify our request, and I'll go to the zoning commission tomorrow night and tell them the same thing I'm telling you tonight, and ask for their approval. Now one thing he does say in the bottom of the last paragraph there, he says, we could go in and request a variance. And that's true. We could go in and request a variance of height. In order to be entitled to a variance, we have to have a hardship. The hardship cannot be self-created or financial. In this case, we are choosing to build a 60-foot building that's got 4 feet of elevator shaft that extends into the roof. That's self-created. So if someone were to appeal to the Superior Court of the granting of a variance for that height variance, we would lose in court because we had a self-created hardship. Secondly, a new case came down about 1.5 years ago on a Fairfield decision. And I think it's called E&F Properties versus the town of Fairfield. And it was a new decision by the appellate court. And what that decision said is that you're not entitled to a variance of the zoning regulations if the property without the variance has any viable use. I mean, that's an extraordinarily difficult burden for the applicant to succeed in justifying a variance. If the building without the variance has any viable economic or practical use, we're not entitled to the variance. Now, that law is really brutal. The legislature's up in arms about it. It's probably going to get changed. But that's the status of the law right now. And I've been doing this a long time, and I don't submit applications on projects, the scope of the Dock Shopping Center that require variances. Why? Because if I go in there, like take Stratford High School, for instance, they required 6 variances to get that thing approved. 6. They were entitled to one of them. Somebody appealed, and it cost the town money to get rid of that appeal. So I don't design commercial properties that require variances because you're holding yourself out to be held up. Somebody's going to take an appeal because you know you're going to lose in court. So this business about that Jay's suggesting variances the answers, variances is not the answer. Zone text amendment is the answer. And I think I've solved his problem, I hope. So I would appreciate a favorable recommendation. Thank you.
Thank you, Mr. Knott. I do have one question. This change that you have presented us, has this been
No.
given to Jay Hibansky?
No,
So
no.
we have no comment from him at this time?
Well, he was, when I called today, he was at a meeting or something, so.
So, if I may speak. I am the staff to the Planning Commission, and this is a matter discussed before the Planning Commission today, not the Zoning Commission. I would have appreciated the attorney contacting me regarding this change when he spoke to me this afternoon. You called.
I hadn't written it yet.
Yes. And the fact that it was written in the last minute shows that, if we don't approve it or vote on it today, if we don't vote on it today, it gets automatically approved. That's the catch here.
The change,
Yes, and if we do vote on it, we are taking a hasty decision because we haven't vetted fully on this. We haven't had a chance to review this and thoroughly, look at what other communities are doing. I mean, I trust your judgment. I'm not saying no to the attorney's judgment, but as a professional, I would have wanted more time to review this and compare what other towns are doing and if that is really correct and how much of an impact this would have had on our commercial industrial properties. And so at this point, I mean,
Well,
this looks great on paper, but I still think.
I'd like to address her
Yes.
comment, and she's right. However, I only got the administrative comments. I only got that thing that I just read to you on Friday.
Well, I asked Jay Hibansky about that, and he said on the application, it's clearly written that it's the applicant's responsibility to reach out to the staff to obtain planning and zoning staff comments. And whenever the applicant reaches out, that's when they get it. Otherwise, as a courtesy, we mail them out when our workloads help us to do it.
I mean, this is not a complicated situation. The redlining that I put on that second exhibit excludes residentials from the amendment, which is what Jay was looking for. I did it as simply as possible. The language is clear. So, anyway, thank you.
Thank you.
Thank you. And the only thing I would say is whenever you're making a regulation change, you're not just affecting one property, you're affecting all properties in the town. It may benefit one property, but in the long term, the impact will be felt on all properties. There is a reason why we have a regulation that seeks consistency. And in this case, it might seek consistency too, but when you're giving that leeway to a property owner to, allow them between 3 and 5 feet, variation, that means across the board, the uniformity, the design, aesthetic might change, like depending on what the property owner, what the property owner's circumstances are going to be. So I would like for you to keep that in mind. I'm not, at this point, I'm not in a position to oppose it or support it because of lack of adequate information. I would have, needed more time to look at this and compare with other examples.
Not because it falls within your jurisdiction, but Erstad Biddle Properties is the second largest taxpayer in the town of Stratford that's asking for this relief. Thank you.
Question.
Yeah.
So what would you perceive as an issue here specifically, other than allowing other businesses to basically fall under, I mean, I understand the hardship here, especially with mechanicals on a roof, I'm more than familiar with that. And it is a project that it's a project I think that'll help the town. I just, at this particular point.
If you call it a hardship, I don't see why not go to Board of Zoning Appeals.
Yeah.
Even if, you know, if the hardship, like Mr. Knott has mentioned, it could be perceived as a self-created hardship, or it could be perceived as a legitimate hardship in terms of the regulation not allowing the applicant to do, you know, what is needed of them to accommodate everything within the height constraints. But, I mean, my only concern is if we do across the board, if another property is doing something and they're, you know, putting 3 feet above, and then there's another property that's coming that needs another 5 feet above, and then there's another property that's coming that's another 3 feet above, your line of design elevation will not be uniform across
But you're not
the
going to be
board.
able to see them from a road. Under the regulation that I wrote, you can't see any of this stuff.
Yeah, it will be screened, is what
Yeah.
Mr. Knott has
And by
said.
the way, this, with all due respect to Mr. Semp, we shouldn't be talking about hardship here. This is not a hardship situation. You shouldn't approve this because you think we have a hardship. You should approve this because it's a good regulation.
Yes.
The hardship issue comes up in the BZA context, which I have no intention to go into BZA for a hardship. Thank you.
Question,
So is the 5 feet that's been in the proposed amendment, the 5 feet is based on knowing that something will go above the roof line 5 feet, like an elevator?
Maximum of 5.
5 feet,
Maximum.
Could be 5,
It's 3.
is less than 5. 1, 2.
And there's no, and all the air conditioners and all the mechanicals and maintenance, there's no limit on how much can be up there, just the feet, the height.
Yes, and it says, it calls about screening, it's all about enforcement in this case. I mean, an applicant,
This is and this is a 60-foot building?
yes. I mean, you know, honestly, we are not looking at this building alone. It's not a zone change for a specific property. And let's not talk about our Stratford right now, because that's not the only, you know, zone change that only we're looking at. We're not just looking at that address. We're looking at the whole town, changing the zone definition of building height, 1.8.
Oh, can I be heard on that? There is only one other 60-foot building in the town of Stratford, and that's the old Ramada Inn down on Lordship Boulevard, which you can't see from anywhere.
yeah,
And this one, you're not, the only thing you're gonna be able to see, you're not gonna see this from East Main Street. You'll see it from I-95 as you're coming from from New Haven. But, I mean,
is it going to be screened to, so that you wouldn't see this
yes,
stuff?
That's why I put that language in there.
Because your first look at Stratford, we don't want to be looking at
That's where we put in
HVACs.
we agreed to put this big, where do you see this Welcome to Stratford sign? It's beautiful, on the back of this building, pointing towards cars coming from New Haven on I-95. As far as enforcement is concerned, all you gotta do is jump on the thruway, drive from Milford to Connecticut, and you can see whether you can see it or not. I mean, you know.
Okay. Can I ask a process question? Do we have 30 days or 35 days to look
From the
at?
date of submittal, so by the time, like, you know, we come to the next commission meeting, we would have passed that time limit, and that would get automatically.
Yeah, I don't, no, we haven't, because we're a week later.
Yeah, but the date of submittal is like the date of receipt of the application, which is the last, you know, zoning commission date or whatever, so.
So we
if
go
it
by
do-
that.
If it doesn't go, if we don't offer a recommendation to zoning commission tomorrow, they still have to make a decision, otherwise, you know,
Okay. I just
it
was-
has to be moved.
wanted to see if we had an opportunity to.
To follow up on
Yeah.
a previous question as to what do you see as the problem might be, other than
Well,
conformity with
zoning is very futuristic. It is not just based on what's existing and what's proposed currently. 'Cause, zoning, in fact, doesn't change anything that's existing.
Excuse me?
Unless you make, it doesn't change anything that is existing unless you make significant changes that have to go back for a review. Now, this regulation is looking at something that may come up in the future or some other, you know, whatever, like.
Okay, so if we have maybe only one building, possibly two, at that height in Stratford, What information are you looking to gather? Right.
Well, I would just want to see, you know, what the impacts were. I would have talked to the, you know, just to confirm. At this point, the way it is written, I mean, it looks fine on paper to me.
I'd like
But I
to-
would have sought a second opinion on this before I made a
I need to
decision.
clarify something, if I may. I may have left the wrong impression. I didn't just write this thing up and submit it. I sat down with Jay, and I told him what I was going to do, and what did he think? And he says, well, as a matter of fact, a lot of towns have an exclusion to the height limitation to allow for these things. The only thing I want to see in the regulation is that it's screened from the street. I said, okay, and I submitted it.
And we appreciate that, Mr. Knott, but we also have a document from Jay Hibansky. That may be, but, you know, the staff is indicating that they have some concerns. And obviously, you have written something that may accommodate their concerns, but it's so last minute. Now, another option, if we send this on to zoning with no recommendation, then that would give Mr. Hibansky the opportunity to then make his comments to the zoning commission tomorrow night, right?
I think we should make some recommendation as a commission, considering the facts that are presented to us. What would you, think would be the impacts for a commercial industrial property? For me, I think the way it is written, I don't see a problem for a commercial property like 3 or 5 feet. But my only concern is that based on some other items that I have been reviewing before, then it's just, sometimes things may fall through the cracks. And, you know, if nobody can measure those heights and make sure that, you know, they're not exceeding or they're screening them properly. So that's more of an enforcement issue here, I think. The 3 to 5 feet.
Can I,
yes.
ma'am?
Hang on,
Okay.
go ahead.
There are several things on this property that come to mind. The first is that we've been working very hard establishing a design standards committee, particularly when it comes to roof lines, whether we're going to require more mansard-style roofs and everything else. This is something that's ideal for them to look at and say, what do we need for the future of Stratford? One. The other thing is that when we gave the approvals on this property, we also gave them a variance to move the existing signage, which is a massive income producer with all the cell connections on it. That thing moved to the opposite corner of the property. Now they're going to put this building in, and they're going to put another sign on top of it. There isn't?
It's just a welcome sign.
No signs on top of this.
Okay.
The welcome to Stratford sign is on the side of the building, facing.
Okay,
facing
good.
90.
I'm glad to hear that. I misunderstood you then. The other thing is,
The dog shopping is in-
rooftops, particularly in commercial buildings, and it's something we should pay attention to, are now becoming valid real estate for cell repeater rentals. That's a huge business. This is a huge physical space that's right on 95. I know that the billboard has massive numbers of cell repeaters in there, but there's no reason that we couldn't have the same thing in there. So the idea of talking about screening is a valid idea that we could talk about as part of our zoning, but I still go back again to our design standards, architectural design standards committee. This is a perfect example of where they should weigh in on what kind of solutions could we have. Because I think it's critical what you see when you come over the bridge from Milford into Stratford. Do we look like a post-industrial city, or do we look like an industrial city that's just spruced itself up? It makes a big difference if you see a flat roofscape there. Maybe that sign ought to go on the rooftop to cover up this, and then it might be a different way to determine it. Maybe there should be a mansard roof on this whole facility to cover it. But even so, you have traffic that essentially is traveling above it.
But under our regulations and our rules, we have to make a decision tonight, unfortunately. That's why I was trying to find a workaround in the process so that we could come back next month, or zoning could take it up and get more information. Like you said.
Could we suggest that he go and visit with the Architectural Standards Committee and have them come up with solutions for this, or offer specifics into how they could offer screening options that we could put into this? Because I don't think we can just say it will be screened.
Any commercial application, when it's in the design stage, has to be submitted to the Architectural Review Board for consideration. So if the design has been already approved, I don't think they will be required to go back, but if it's not been approved by the zoning commission, then they can go.
We have been to the Architectural Review Committee, and they were interested in two things. They were interested in putting benches on East Main Street in the lawn area between the sidewalk and the street,
Properties.
and cutting down some trees, or putting trees in the planting area 15, 20 feet high, so that when you drove up East Main Street, you wouldn't be able to see the Starbucks and the Chipotle sign. So, and then they wanted the building beige. We were proposing a gray building. They wanted it beige. They wanted the benches in there that nobody was ever going to sit in, because they weren't part of the Chipotle restaurant. They were out in the street, and they wanted trees that were going to block. So when we went back to the zoning commission after having gone to the Architectural Review Board, we told the zoning commission that we thought these recommendations were absurd for a number of reasons, and the zoning commission agreed with us and did not require us to impose any of those suggestions on this project.
Mr. Knott, did the Building Review Committee know about these changes?
No, I didn't know about them.
Well,
So they really haven't weighed in on
No,
this?
they have not on this, no.
Madam Chair, I have one thing to add. I am also staffing the Architectural Review Board, and I remember Mr. Knott representing the client, and the client actually flying down to our ARB meeting to discuss the design of the property. With all due respect to what Mr. Knott said today, I would like to contradict what he has mentioned about the committee making absurd recommendations. They have really carefully thought about this design, and every single thing that they said, the applicant was willing to do. And he said they were willing to work out a solution for that. They wanted placemaking opportunity, considering the fact that we are going to make this a complete streets town, and we want to eventually expand the bike ped network in the town. So giving opportunities for people to get together and make it more pedestrian oriented. Those were the basis for recommending benches and recommending some trees, and in the color scheme of the building was specifically what the applicant said he would work with the Architectural Review Board to make sure that they put on a color that is agreeable to the board. Because if I remember, they presented schematic drawings in gray color, which felt like it was very dull and unappealing, and that was the main recommendation. Now, when I went to zoning commission, definitely things have changed now that there is no communication directly from Architectural Review Board to the zoning commission. And they did, agree to some recommendations, but not all of them. And in this case, my only question is, why didn't the applicant think of this when they were designing the building? And why do they have to, when they got everything approved, when they went through a design review process, now why are they doing this in the last minute, that they want a 3 to 5 feet adjustment on the roof?
Mr. Knott?
Well, as far as we did change the color of the building to beige. As far as why didn't we think of it when we were designing the building, I only know one person that has been alive during my lifetime who never made a mistake, and that was my mother. And the reason I know that is because she reminded me every day that she was always right. So we make mistakes. people who design shopping centers make mistakes, but my mother never made a mistake.
I'm glad to
So,
hear that.
like, we are accommodating one person's mistake, and we are essentially changing a regulation for the whole town.
Yeah, I understand. Yes, Sandra?
No, the apparatus is going to be located wherever the elevator is. And the elevator is going to be located wherever the elevator is designed to be located within the building. So it's the location of the elevator that's going to drive the train as far as where this thing is going to be. And then the air conditioning stuff will be put in that same area.
Is this a truck elevator?
I don't think so. I don't think so.
In this particular case,
If you want to change it to 4 feet,
I understand, I'm agreeing, but what Mr. Knott is saying, in this particular case, it's already designed. Yeah, yeah.
I would have no problem with you changing it to 4 feet if that would make you, because I think that's where we're going, 4 feet. But I figured 5, just to be safe.
Well-
And, you know, we're talking about 1 foot, 60 feet off the ground. Who can tell the difference?
Commissioner Zalik made an interesting observation and an important point that has to be considered before you vote yes or no to this. We have no control over where this 5 feet or, less than 5 feet change would go on any commercial or industrial property would be, taking this into consideration.
To that
As
point,
written.
is there not a plan we saw?
Sorry?
Is there not a plan that shows?
Elevation.
Yes, it is, the plan determines it, and if they...
Where
if
the elevator is.
Yes, and in some cases, the plans might indicate elevator right at the axis, at the front. And in that case, if the applicant for that decides to go up to 4 feet above the already designated height limit and would want to put a mechanical equipment there, no matter how much you screen it, it is still going to be a different roof line compared to the other properties in that area. So again, there are some really, that's a valid point to consider before you vote yes or no.
Question, though, if somebody was building a 40-foot structure and we're putting in a elevator shaft and it exceeded another 4 or 5 feet, it's really an aesthetic issue more so than anything. I don't think we can really control that. I don't think we can really make a determination of whether it's aesthetically pleasing to one group as opposed to another. So
Well,
Sort of-
the applicant has had enough time to think about this. We are under the presumption that the applicant would work through with the regulation and come up with the best design, and not after the fact think that, oh, I have to accommodate 4 or 5 feet now. There's a reason why we have a regulation in place, so that people work with the regulation, make it effective.
But to Mr. Sem's question, if the building was 40 feet, and then they put an elevator or HVAC on top, because it's under the 60 feet,
Oh, under the 60 feet is fine,
then
yeah.
but that's
You
what
would
I'm
see
saying.
that,
There's
yeah.
no, aesthetics
But
don't, and I'll use Stratford High
To
School.
come to that-
I'll use Stratford High School as an example because, I was involved with that. And there's air conditioning units that are up there, and I believe the height of Stratford High School is 50. I believe it's 50 feet. So, you have the air conditioning units above there too, but it's basically where the mechanicals have to go based on the plans and everything else, as well as, any elevator systems that are in place also. So from an aesthetic standpoint,
Yes, but the good thing is now you have an architectural review board, unlike the past. And the thing is, anything that is less than 60 feet, that is having mechanical equipment on top, the ARB has significant leeway to propose recommendations.
yeah.
But again, ARB is just advisory, and ultimately it's the zoning commission that decides.
Yeah, and I think if aesthetics are the issue, if you look across the street to the dock, that's the first thing you see is their roof line, and it's, there's air conditioning units all over the place and nothing's covered. I mean, you talk about, you know,
It's
something
also
that's
under
not very
60
appealing,
feet.
yeah.
Yeah.
Any other comments?
I do have a concern. I don't have a problem because we're talking one building in Stratford, and I don't see this going into the future out of control.
It's really not one building. It sets a precedent for the future.
It does, but
Like,
I don't believe it's getting out of control going forward. But my
Stratford-
question is about a truck elevator versus a person elevator. It's going to be much larger up there, 5 by 30.
Oh. Was it a truck?
I asked the question.
Is it a truck elevator or?
I don't think it's a truck elevator.
It's a storage facility.
Okay.
The storage facility is nice.
Thank you.
You go to the parking lot, you have a key code to get into the building, you load your stuff onto an interior elevator that is it's not a passenger elevator, and you take it up to the 3rd floor or whatever and put it into your thing. But you don't drive trucks into the building, as far as I
No,
know.
probably not. But this would affect like Stratford Army Engine Plant if it were ever renovated or built up, because that has an approval from us for, I believe, 60 feet.
60 feet was our our maximum.
Right, so,
Commercial and for residential.
so it's not just this. We know in the future, there's gonna be a 60-foot building down there, you know it. So. What are your druthers? What would you like to do? Mr. Watson, were you gonna say something?
I will just say one last thing. It is worth being concerned about this because this is at our front door. It is important, the aesthetics that we offer the rest of the world. If Stratford wants to be something more than a post-industrial city, then we need to start making sure that we visually are creating that image. This is something that's very critical, and I understand from Mr. Knott's point of view, from his client, it would be easy to say, yeah, let's let them have it, but I also think that it weakens our ability of planning and zoning to simply say, oh, well, in order to allow them to do it, let's just let anybody in the town who does anything in the future do the same thing. That might make sense if we had governing rules that had meat on them according to our visual design, our architectural standards committee. There are towns that say, there are towns that say there are no billboards, no whatever, nothing visible from your rooftop, period. We're not being unduly, and I will tell you, I guarantee you, they're not going to stop building Panera because of it. They're going to find it, whatever we say, they're going to find a way to make it happen.
Conclude, because there is no staff report here. As a town planner and as an official who has practiced planning for nearly 17 years, I would never make a zone change on the fly. I would always back it up with what is, the legality, what is practical, whether it's efficient, and whether it's going to be effective. And for me to make a zone change, I would definitely want to know if there is going to be more than one property in the town that will be affected by this. Not just because one property feels that, they can't have a hardship at Board of Zoning Appeals, they can just change the regulation and it's not going to affect the other properties. I would base my, assumptions on more concrete data that's out there. How many properties are being affected in the town for this, for me to think of a zone change here? Have we had any complaints in the past regarding this on any other applications? Is it legal to do that, considering that, there is no community vision or there is no, a publicly vetted discussion on this?
There's going to be a public hearing tomorrow night.
No, yes, I agree, Mr. Knott, and this is, I'm not disrespecting your opinions here, I'm just talking as a planner. You're an attorney and you're rightful in your case, but, you know, is it going to be effective in the long run for what its purpose is intended to be? And those are the factors that we should consider today as a planning commission before you make your vote. And then it will open up to zoning tomorrow, like Mr. Knott said, where if the commission, based on the public hearing, decides another way, that's fine too. I mean, it's not a popularity contest, although I would say it's mostly based on law and what is going to be most, the highest and best use of that property, or the properties in the town, based on this regulation.
May I comment on that?
Sure.
I appreciate Susmitha's credentials and her opinion, and I've worked with her before, and she presents herself very professionally and reasonably. 17 years as a town planner. I've had 45 years as a zoning lawyer. In this town, I did the Dock Shopping Center, the Home Depot across the street, where the LA Fitness is on the other side of Ferry Boulevard. I did the Big Y up on Hawley Lane. Every major shopping center in this town, I did the zoning for. I know what's reasonable, I know what's legal, I know what's unreasonable. Asking for a 5-foot modification on top of a 60-foot high building is de minimis, and it's legal, and yes, it does apply to everybody, but this is crazy. I can't believe we spent the last 45 minutes talking about this.
Mr. Knott, you missed the point that this could affect other buildings throughout the town. It's not just talking about one building.
Right, and so under Mr. Sneff's example, you got a 40-foot high building in a light industrial zone, 60-foot zone. The height max in the 60-foot zone is 60 feet. The building is 40 feet. That guy could put a 15-foot high whatever on top of his property that'll look like hell, and it will not violate the zoning regulations. And this regulation wouldn't be triggered at all. So you could have conceivably 35, 40, 45, 50-foot buildings all over light industrial properties in Stratford with ridiculous appendages sticking out of the roof that this regulation wouldn't affect at all. The aesthetic argument does not fly.
Yeah, sure. Yes, and I don't mean to, I'm not a lawyer, I don't mean to argue with Mr. Knott on this, but I would like to say something about the 40-foot and the 5-foot above 40-foot. You're still under that roof line for design. The 60-foot is the cutoff, where your sky, you know, I would perceive that that's the maximum skyline that you would want of your, you know, concrete structures or brick structures or whatever. But our regulations do ask for screening of mechanical equipment, and we do have an ERB. We do have our zoning commission that is very effective in making sure that something doesn't protrude awkwardly. Otherwise, you know, in all the 45 years that Mr. Knott has been here, we would have been, you know, seeing all these mechanical equipments everywhere not being screened, and it's great service that we have some really good buildings in this town. If it were another town that I had worked in, public would be banging on your doors, asking why. It's just that, you know, the fact that is most concerning to me about this is that
nobody, including anybody who may be interested in zoning, has had an opportunity to look at this regulation. And, you know, in the last 35 days, nobody looked at this. It's just been presented to us at this meeting, and now we are voting on something that nobody has had a chance to look at and comment upon.
By the way, there's no residential properties within 750 feet of this property. No residences whatsoever.
In this particular case, that's correct.
May I?
You just said something. This was just presented to us tonight. So the clock starts tonight.
Well, no, the application was submitted. It's just an exhibit that's presented it as an amendment.
But it's been presented tonight.
Can I explain that?
Because
please?
if we go back to the original proposal,
Right.
then we could deny this one
Yes, you can.
and have Mr. Knott submit.
No, that's not what I'm
His-
going to do. If you deny it, I'm going to go forward tomorrow night with the zoning commission. Statutorily, every commission has 35 days from the night of the public hearing to make a decision. So you don't have to make your decision tonight. You could postpone it to the next meeting, and then 5 days after that, theoretically. You have 35 days legally to make a decision. However, if you don't give a decision to the zoning commission by tomorrow night, then they're going to act on it anyway. If you,
Maybe,
if
yeah.
you, well,
Yeah.
trust me. If you approve it, they're going to act on it. If you deny it, they're going to act on it. If you take no position on it, and I didn't want to sandbag you earlier when you raised this issue, if you refer it without a recommendation, that's the same thing as referring it with an approval. So
I was afraid of that.
don't do that.
I guess my biggest problem is that our zoning administrator has recommended to us to deny it. Our town planner is saying that they have not had enough time to really look at this change because it was just presented tonight. From a process, I just think it's flawed, and quite honestly, I'm not ready to approve this without having the staff truly have the time to weigh in on it and give us their best thoughts, because they're the experts. Yeah.
May I make a comment on this? This same property was the property that we gave either a variance or we changed the regulations on moving the existing billboard, which the moment we did that, it made the elimination of all billboard regulations for us in the town because we established a new precedent
Right.
by allowing them to put up a new billboard. So now, anybody along Stratford's line, along 95, can come in and use that as their reason for being.
That is not correct. That regulation that you're talking about allowed a billboard to be moved from one location on a property to another location on the same property. It didn't allow a billboard from Stratford Avenue to be moved down to Barnum Avenue. If you remember the regulation, I do because I wrote it, the billboard has got to be moved from one location on a property to a second location on a property. So we didn't open up the doors.
But
to
our
billboards.
POCD clearly states that we should be moving towards elimination of billboards.
POCDs
along-
are recommendations. Zoning is
Well,
real
I'm
life.
sorry, but that's what the ruling document of planning is.
But it's not
is
a
the
ruling
POCD.
document, it's a recommending.
It is for
It's a
us.
recommending document, not a ruling document.
I think in general, that's what Mr. Watson is saying, that we have taken the position of always trying to stay within the POCD. That's kind of our philosophy because they took years to write it, it cost a lot of money, a lot of people had their input, so to go against it, we'd have to have a lot of information showing us that we should go against the POCD and not agree with it. Yes, Mr. Stately?
So have you and Jay had conversations about this after Mr. Knott met?
Well, we just talked very briefly about this, and Jay mentioned this afternoon that he was not comfortable because the proposed regulation was proposing height changes, and it might affect the aesthetics. But you know, if you were to approve this, you would have your own basis for this. But if you were to disapprove this today too, you may be able to say that, you know, there is, the process has been flawed, that, you know, we've not had enough time to vet on this and compare how many properties are actually impacted currently and how many properties would benefit from such a change.
May I ask one more question about
Yes.
that? If we were to say yes to this, are we effectively raising our limit to 65 feet?
Yeah, kind of.
Which we
60
have
plus
fought
or
for,
minus
if I remember correctly, we fought for several years to establish a 60-foot limit. There were 70, 90, there were all kinds of limits. We settled on 60, not as our choice, but as what was most pleasant to developers, that they needed that volume in order to make their dollar.
Yeah, and there are places in the town where the CA zone abuts RS4, and, you know, it affects all commercial properties and industrial properties in the town, and including those properties that are sharing their property boundary with a residential property in the town.
I would suggest that we take the original proposed amendment and send it to zoning with an unfavorable recommendation based upon the town administrator, planning and zoning administrator's comments, and the town planner. And if zoning wants to take up this change, let them take it up, because I just think the process is flawed right now. I think it's very unfair to the staff and to this commission to all of a sudden hand us a piece of paper with changes that no one else could comment on from the staff.
There's also not a real hardship, because there is other avenues that can be explored to get this done.
They could resubmit it as the new proposed amendment. We're just denying or sending to zoning with an unfavorable, the original amendment.
Question, it's for Mr. Nutt. So tomorrow, through zoning, if that's delayed, what would that do to the project? So if zoning waited another month to make a decision on this?
Well, I mean, this particular aspect of the shopping center development is approximately $20 million. And between the three buildings and the infrastructure, the juice or interest on the carrying cost associated with the land. I mean, they're not paying interest on $20 million yet because they haven't built the buildings. But they did pay a lot, over $1 million+ for the land. So they are paying carrying charges on the land. And every month that goes by it costs, I don't know, $10, $15, $20, $25,000 in carrying charges. Now, to Erstad Biddle, maybe that's not a big number. To me, it is. But it shouldn't, nobody should have to pay it. This is a de minimis request, and it's not going to change the height limit in this town to 65 feet, because the extra 5 feet is only for equipment. And when you think about elevators, if the elevator is going to go to the 5th floor, the elevator shaft is going to go through the roof at least 3 or 4 feet, because that's how elevators operate. So, I mean, make it 4 feet, make it 3 feet, but, you know, something.
Well, my feelings are if you have a chance to review this and you come to the conclusion, you know what, it's not such a bad idea. We've looked at the plans, we see everything that's going on, not such a bad idea. We can, you know, we have a favorable recommendation, you know, to us, and then we go to the zoning commission with a favorable recommendation. That's all for naught, though, because if he goes tomorrow, they can approve it anyway, correct?
You're correct, and I think if this commission was a Board of Zoning Appeals, not Planning Commission, you'd have been in a more comfortable position to vote on this favorably, considering just one property. It's just that you're opening to a can of worms. There are good developers and there are not so good developers in the town. And there are people who abide by rules, there are people who always, find their own way around the rules. And I'm only worried about those that might actually take advantage of something, to maximize.
Well, you
something
got to
else.
admit that Erstad Biddle is a good developer, and
Yes,
they
I
abide by all
understand.
the rules and regulations, and everything they do
Yeah.
is above board and pristine.
But it's not project-specific, that's the problem.
Yeah, because it is a text amendment. It will affect the entire town. That's,
The difference is between if you approve it or if you deny it. If you approve it, we need 3 votes tomorrow night. If you deny it, we need 4. That's the difference.
but at least then maybe the staff will have more time to review and study this change. I understand they don't vote, but they do make a recommendation. And right now, their recommendation is to deny.
And I think I've got valid reasons why it shouldn't be.
And to some extent, I understand it, but when we're making a change that affects the entire town, to ask us to make that decision based on a piece of paper we're handed right at 7 o'clock, I just don't think that's fair or the right process. All due respect, I'm sure this is something that came up at the last minute, and, I like to be flexible, but not when it's going to affect the entire town.
Move forward on this?
Sure, you want to make a motion?
No, I don't have enough time to analyze everything.
I'm agreeing with you, but we have to either send it on with no recommendation, which is not the best, or an unfavorable, and zoning is going to do what they want to do anyway, so.
Just one thing, before you make a motion on this, as a staff, I request Mr. Knott and any other attorneys and applicants that may be watching this by television or that may watch this planning commission meeting as a replay later on the town website. Section 8-24 and text amendments, we only have limited time frame to review and offer an opinion. So it would help us as the staff if we know this at least, a week before, so we can communicate this to our commission members and we can give an informed decision on these, so as to avoid a circumstance like these where, the public hasn't had an opportunity to review it. I mean, the fact that we have commission meetings is not just for the commissioners to vote on something. We have these meetings so that everybody, including the general public, have an opportunity to review these amendments and critique them and come and voice their opinions if they have to at the public hearings or otherwise with the staff. So I don't know how things were run before, like 10 years ago, but right now I think we all need to abide by the simple premise that 8-24s and text amendments are under strict timelines, 30-day, 35-day turnaround. So please, please, please bring us any proposed amendments beforehand, not at the meeting.
Well, at the zoning commission, if there's a public hearing, isn't it going to be based on the original proposal?
Yeah, but I have the right to amend it at the public hearing.
But it's already posted in the paper as,
The text of the amendment is not
Is
published
not
in the
posted.
newspaper.
I think we should look at the process, because it seems flawed to me.
I'd like to comment on what Smitha just said about what happened a year ago and what happened 10 years ago. What happened a year ago is the same thing that happened 10 years ago. When administrative comments were written by staff, they were sent to the applicant a couple of weeks before the public hearing. So if there were engineering issues that we had to get resolved, we could refer them to engineers. If there were drainage issues, we could refer them. I got this last Friday. Now, maybe under the new regulations, I'm supposed to go there and pick it up. But for 45 years, they've been sending them to me. And I've been getting them a couple of weeks in advance. If I get them a couple of weeks in advance, I can deal with them a couple of weeks in advance. So,
Well, we understand that you got this on Friday.
You're going to do this?
So you should be able to understand that they just got it and we just got it tonight. So we're all in the same boat. Does anybody want to make a motion? Mr.
I'd like to
Vigliotti?
make a motion to send this to zoning with an unfavorable recommendation and hope that they will take into consideration the limited amount of time we've had to review this, and that they will also appreciate the lack of review when they make their decision.
Okay.
Second.
Second by Mr. Watson. Any further discussion? Hearing none, all in favor say aye. Aye. Wait a minute, who said aye? And, okay, all, those saying no? Mr. Staley, what did you?
Abstain.
You abstained. Got that? He's against.
It's a no.
So it's 3 in favor, 1 abstention, 1 no. Okay? Thank you, Mr. Knott. Oh, goody. Yeah, I kind of figured.
Oh, you're James Farm also? He's our regular Santa tonight. Thank you.
Thank you.
Thank you very much.
Okay, on the agenda, this is for a zoning change application for 325 James Farm Road.
Good evening. My name is Barry Knott. I'm a lawyer with the firm of Knott and Dunn with offices at 1656 Main Street, Stratford. And I'm here this evening on behalf of William Fedorko and the estate of David Fedorko, who are the owners of this 6-acre-plus parcel at 325 James Farm Road. And as was indicated, we are seeking a zone change for this property from RS1, single-family 1-acre zone, to RS2, single-family half-acre zone. The first exhibit that I gave you is simply a copy of Section 4.2 of the zoning regulations that shows you what the dimensional requirements are for an RS2 zone. So it's got to be a 20,000 square foot lot, 100 foot of width, 125 feet deep, et cetera, et cetera. So it's the second largest residential zone in the town of Stratford. Now, if you look at Jay's administrative comments, and these are addressed to you, they're dated October 15, 2019, and he says, to the northeast and south of this property, a majority of the neighborhoods are RS1. I'll get to that in a minute. But down below, I've highlighted in yellow, in the third paragraph, says, as identified in Figure 7 on page 21 of the Plan of Conservation and Development, the residential open space future land use is characterized by larger residential lots and residential developments with ample space components. The third exhibit is a copy of that page 7 from the Plan of Conservation and Development. And I should have highlighted this better than I did. But I just sort of the approximate area where we're talking about here. This is what you look James Farm Road over the parkway, and just as you get over the parkway on the left is this parcel, okay? And the parcel is zoned RS1. Jay says the area is zoned RS1. The second and third exhibits are assessor's maps on which I highlighted in yellow the RS2 zone in that area. And if you put map 5018 on the right and map 5018 on the left, you will see that the RS2 2 zone runs all the way to, from James Farm Road in front of this parcel, all the way over to Upper Cut Spring Road where Circle Drive is. That whole area is zoned RS2. Now, what is the significance of those 2 exhibits to Jay's comment, where he says, Figure 7 talks about residential open space being recommended in this area. If you look at this map, this map from the POCD, all the land above the Merritt Parkway is in white. And if you look at the schedule over on the right, it tells you what the different colors mean. And white means residential open space, okay? It got cut off, but that's what it says. So all of that white above the parkway and below the parkway is supposed to be residential open space, and Jay suggested in his memo that it's all supposed to be zoned RS1, single-family residential. However, if you see from that exhibit, I've highlighted with red ink, I've encircled the property that's on those first 2 exhibits that I highlighted in yellow. Those yellow encircled properties are the red encircled properties on the last map, the one that was the 4th item in your exhibit. And what you can see from that is that the RS2 zoned property already extends into this area up to that little pink lot there right by the Merritt Parkway. That little pink lot is our property. That's what we're asking you to change the zone to RS2. The yellow lot next to it is a couple of acres owned by the CLMP. Don't ask me what they're going to do with it, but that's not the subject of tonight's application. So what we're saying is that that little pink thing, which is 6 acres, should be zoned RS2, just like the property across the street and all of the properties on both sides of Harvest Ridge Road, all the way into the Vargas subdivision that goes up off of Cut Spring Road. So, and as far as his comments, future land uses recommend approximately 1 dwelling unit per acre. If you look at that area that I just described, you've got Orono Country Club golf course in that area. When you start doing 1 unit per acre, if you take the 150 acres that comprise Orono golf course, that reduces the density significantly. It doesn't mean that every lot's got to be a 1 acre lot. It just means that from a density perspective, in the area of this map, it should be about 1 acre, 1 unit per acre. Well, there's already half-acre zone in that little, whatever it is that I outlined in red. And this proposed zone text is consistent with the zoning directly across the street. Now, let me tell you one thing. As part of the zoning application, I had to send letters to the abutting property owners, as you do when you have a public hearing on any land use. So I sent letters to the people across Harvest Ridge, James Farm Road, et cetera. And one of them called me, but a lot of them called Joe Kubik, Skip Kermay, and the neighborhood association that's opposed to the affordable housing project that they've been fighting up on James Farm Road for the last 5 years, okay? And when they saw the letter from me, these neighbors thought, uh-oh, they're coming in with an affordable on this piece. That's why he wants to reduce it from RS1 to RS2. And I found out about that from Attorney Kermay. And as soon as I did, I went back to him. I said, listen, if we leave this as RS1, then we can get maybe 3, 4 lots out of it, maybe. On the other hand, if we could change it to RS2, we might get 6 or 7 lots out of it, thereby making it more valuable. This property might be an attractive piece of property to sell to an affordable developer if it was zoned RS1, because zoned RS1, the value of it is less than it is zoned RS2. My client is willing to put a restriction on the land records, prohibiting any use of this property other than single-family residential in perpetuity, so that an affordable housing complex, or whatever the next crazy scheme is, can't come in on this piece. He will restrict the land in perpetuity to single-family residential. And I'm making that commitment to you, and I'm going to make it tomorrow night to the zoning commission. So the fact, Jay was probably looking at the first map I showed you when he wrote this, where everything looked white. But everything isn't white. That area that I outlined in red is already RS2, and it abuts our property.
Attorney, not on this long map here that's outlined in yellow.
Yes, the two of them.
Where is the property you're talking about? Trying to figure out where Parkway is. Where? Yeah. This one here.
It says 4.2 acres on this. Oh, excuse me.
Okay, I'm not, is it this? Wait a minute, I can't see who. I guess I have the wrong map, because I am not seeing it. I got 40.18. Okay.
This is,
This,
and it's,
I got it now. Okay.
it's the partially wooded area, right? So when you're taking that turn, it's the wooded area right to your left. Okay.
So, Mr. Knight, it goes all the way from the Merritt Parkway to the Connecticut Power property, and all along, and it abuts a homestead lot. That driveway comes all the way through to James Farm Road?
No.
Yeah, absolutely. I was there, I walked it.
That's the lot.
Make sure you have the right map.
Yeah, the second map, if you go like this,
Yeah,
if you go like this,
you've got the
Here,
right map.
right here.
this is,
This is it. This is it, right here.
The heck did
I know
get
it.
a 40.18?
go like this. Put the two maps together, like this. Here's James Farm Road. This is the piece here.
Right.
This yellow is all RS2.
I'm not concerned with that. That wasn't my question. You have a homestead lot here that goes all the way to James Farm Road.
Correct.
And you have this owner asking for the change.
But these two properties are owned by the same person.
They are?
Yes.
I didn't know that. Okay.
But this one was not the subject of tonight's application.
No.
Because it's already zoned RS2.
Okay.
That's 335. Already owned, already RS2.
But on his original map, he sent us.
Now, is there a building on this property?
There's a building on 335. There's an old ramshackle house on 335. But the other house might have a shack on it, but the big lot might have a shack on it. But
So, Madam Chair, once you get right over the bridge, the Merritt Parkway Bridge, it's that first
To the left,
parcel
it's
to the
all-
left that's got trees.
Yeah, okay. I'm just trying to figure out where it stops, because on this map, there's a building on that area
I
you
think that's
pointed
just
out.
an old shack or garage.
So this is all
Right.
This is that CLNP.
Right,
site,
which
and
is
the pink-
this.
Yes, and the pink here is what,
Which is this. There's a building there,
yeah, and they wanted to, I think maybe they would
right?
change the zone, and then maybe they would subdivide the lots.
Okay. And across the street, across James Farm Road, that's all
RS2.
RS1?
No.
No,
Across James Farm Road from this parcel are the houses that are on Harvest Ridge Road. Okay?
no, they're on James Farm Road.
But Harvest Ridge,
Here's James Farm. What's that?
I think this is turning into this one, this road here,
That's James Farm Road.
that's James Farm, okay. This is what he's talking about,
I understand, I'm asking what this is.
That looks like our street. It doesn't look like large lots.
That's why I'm asking.
no, across the street in front of this property is, half of the property fronts on James Farm Road, and half of the
Right.
property fronts on Harvest Ridge Road.
Right, and the part that's on James Farm Road, what's across?
RS1.
RS1,
The part that's on Harvest Ridge are the houses that are on both sides of Harvest Ridge Road. Those are all RS2.
okay, within the yellow,
Yes.
okay. Just wanted to, thank you, okay.
Question?
Yes, Mr. Staley.
Mr. Knott, so what you're saying is that both lots are owned by the same owner?
Yes, correct.
And was it 95,000 one of them is?
I'm sorry?
95,000 square feet, one of them?
No, forget the dimensions of the lots as they are now. These lots are going to be combined into one lot that's going to be about 7 or 8 acres.
Should be.
We can combine these two lots.
ask,
They're owned by
I'm
the
not
same family.
positive,
So
but
we're
I
going to
think
combine
that's
the two
probably-
lots and then divide them into
We're looking at
residential lots.
approximately 10 to
Pro-
12?
no.
Single-family homes?
6 or 7.
6 or 7?
Because if you have a subdivision greater than 5 units, you have to dedicate open space as part of your subdivision application. So technically, we may have enough land for 7 or 8, but when you start cutting out the open space, it may down to be 5, 6, 7. The good thing here is, we got no infrastructure costs, because the road's already in. We don't have to put in the road here. I mean, this is a significant benefit. And it will keep this property from being developed by some of these pirates that are going around.
Mr. Knott, I have a question. Is it on septic or no?
That's a good question. I know that Judas Drive is on sewer. Judas Drive is up the street a little bit.
Yeah.
So whether they go down there that far,
Yeah, they go to Judith.
I do not know. If Judith is on sewer, I imagine these will be on. And all of these Harvest Ridge Road houses got to be on sewer.
They're on sewer?
Yeah,
Okay.
sure. Absolutely. Chris Vargas built all those Harvest houses.
So adding this, we'd have to add to this sewer line.
No.
The sewer line's there, but we'd have to.
Sewers are in the street
I-
already.
I understand that, but it does add to the sewer plant and what goes to the sewer plant.
6 houses? Yes.
Yeah.
Okay.
It just,
Oh, this is where the right-of-way is for Connecticut Light. It's right down through here.
so that answers your question, yeah.
It cuts across.
They own a piece of that property. They own a piece of that property.
There's one through this, and I don't know where. This is CLP, and that's CLP right-of-way.
Any questions, comments? Mr. Jaley, I think, did you get your questions answered?
Yes, I was concerned about the density factor, the area. Come up to the Mayor Parkway, and we're in a school zone, and those are my questions.
By the way, the woman that called me, I told you one of the neighbors called me, it was Mrs. Guggenheim. She lives directly across the street, and she said she was in favor of this request, for whatever that's worth.
Yeah, go ahead.
I think, based on what Mr. Knott has shared here, the character of this whole area in general is changing, and it's like not what our plan has envisioned it to be, because sometimes there are some developers who want to do affordable housing here, some who did, cluster subdivisions. So while I do agree that it is RS2 in nature, this is a larger question to the commission, whether you want it to continue to be high density moving forward because of the demand on this site to develop it, or just, preserve it as valuable land for large lot houses. This is something that, when the previous POCD has visualized this, it wanted it to remain large lot, obviously, because, of the presence of significant natural resources like that would endanger the habitat otherwise. But again, like Mr. Knott has said, people have changed the character of the immediate area significantly, so it's up to you.
As long as we're talking about habitat, there are wetlands on this property, not on this property, but on the house next door that we also own, right around the back of the garage, which is gonna come down. Both of those, there's a little bit of wetland pocket there. There are no wetlands whatsoever on this site that I'm talking about.
Okay.
No wetlands. Do the wetlands stop at the property line? No, they don't even go, they just wrap around the back of the garage where the existing house is on 335. It's a very small area of wetlands. They don't even extend from the garage towards the property line on this parcel.
And this
It's
is
very
335.
small area. No,
And that's,
no.
no, I think, what it-
So the, backing up to the Merritt Parkway,
335.
we're looking at approximately 6
He says 335.
family homes,
6 or 7.
residential.
Yeah.
6, 7. The state has no saying anything with the Merritt Parkway abutting us.
No. Matter of fact, when I was first married, I lived on Sunridge Lane, which is off of Oak Ridge Lane, which you go up Cut Spring Road and make a left into that subdivision. All of the houses on the left, they're half-acre lots too, by the way. They all abut the parkway, every one of them. So they got trees in the back, and it's not a big deal. I lived on Main Street all my life. The trucks go back and forth all night long. I never hear them.
You see a problem?
No, in fact, it's, the one thing I find is people throw their junk in, just garbage.
sorry, it is a different subject, but anyway. Any questions, comments, recommendations, motion?
So I go by that property all the time, and the one thing I do find, especially with the middle, the kids that go by there, it becomes a sort of a dumping ground for the kids or for cars passing by, and to clean it up a little, I think, it would be a good thing, and especially putting some houses in there, and,
I agree that, I don't think it's a question of whether we should put houses there or not. It's a question of how many houses do, that's the question.
that's the question.
Because by the current zoning, they can put houses there. There's nothing stopping anyone from putting a house there, or 3, I think. Or an affordable housing complex, which would still have to get through. But the owners would have to sell it to a developer who would do that. Or they could sell it to someone who just wants to put 3 houses on it. So the question is the density, yeah.
Yeah, concerning the density. So if this proposal was moved forward favorably, and it was going to be 6 to 7 houses with all the restrictions of open space and so forth, can they be held to that?
Be held to the restriction?
Well, the proposal, 6 to 7 residential houses.
You're gonna decide how many houses go there, because we have to come back to the planning commission and submit a subdivision application. When I was doing my rough calculations, I was getting like 7 with the open space calculation. So you're gonna control, and that's with 150 foot of frontage, 135 depth, with 20,000 square feet. These lots happen to work out very nicely with that other house fit into the pattern. So you're gonna control that. And once we get subdivision approval, then we gotta build houses that conform to the subdivision.
Mr. Knott, I have a question. I'm still not clear on this. On the map that you showed, there is a fluorescent yellow and a fluorescent pink color marker on the bigger map, and everything else looks white. So when you said it's RS2, do you mean that they were built to RS2 standards, but they're still in RS1 zone?
Mr. Knott? Oh, you're answering? Yeah. Okay.
Okay.
You can see the zone line, and it's not very clear. This is RS2 to here, and then this becomes RS1. So this piece is RS1, and all of this is RS2.
So in here, this piece is RS1?
Yeah, that's the UI piece. That's still RS1. It really should be zoned RS2, but we don't.
And what is this?
Those are all RS2.
RS2?
Everything that's within that red line is RS2. So here's the zone line. It's here, and then this big piece is the piece that we're here on. And the wetlands, you can see the wetlands around the back of the,
Not all of that.
yeah.
Oh. Okay.
And here are the wetlands. Here are the wetlands. See the wetlands right around the back of the old house here.
But they don't extend over here.
Or here, anywhere. This is RS2 here. This is RS2. This is all
This
RS2.
property zone, these two properties are going to the same.
This and this are.
This one and this one.
This is the new house on Harvestwood Road. So RS2 goes to here, all the way up to here. This is RS2, way up here. But this piece is RS1, and it just makes sense to me to make the whole thing RS2. Because everything across the street is RS2 also.
Depending on which is across the street.
Well, half of it is.
Okay.
This half
Yeah,
is across from RS1.
and this is RS1.
But this isn't spot zoning though.
This is zone RS2.
There's more than no justification because of the adjacency of the RS2 zone. But this would not.
I think that should be okay.
One question, Mr. Knott. You referenced Orono Country Club, 150 acres, that has 2 buildings maybe on it. What was that about?
The argument I was making is that this area above the parkway is designated in the Plan of Conservation and Development to be low-density residential, approximately 1 unit per acre. And when you look at all of the houses that are up there, it's approximately 1 unit an acre. However, you've got to add to the acreage that is the golf course, 125, 150 acres. So if you throw that 150 acres in, it dilutes the number of units per acre in this area because you got 150 acres of open space, which is the golf course. So we probably have 0.75 units per acre.
Is it not actually designated as a golf course? And if it is not, it will be open space?
It is, golf courses are open space.
Yeah?
golf course is.
Okay.
Yes.
Was reading the land records the other day.
If we were to make a decision based on the plan of conservation and development, then, we have to abide by the book, what the book says. That's our Bible. And if the Bible says this is what we want here, that's based on a community vision, and we have to abide by that. We can't go, our main job as a planning commission here. Tomorrow, it'll be a whole different ball game because it's going to be a public hearing, and there definitely they will be mostly looking at this from a community standpoint and as well. But for us, it is more about consistency with the POCD. What I think Jay Hibansky has written was based on the POCD, future land use plan for this area. But there is one thing that the POCD also recommends that is worth considering. It's about promoting more affordable housing opportunities and in the town. And probably, having 6 homes instead of 3 homes would actually help, the developer sell them at a different price point and making that more affordable. And that's the only thing I can think of in terms of consistency with the POCD for this application.
I'd like to make a recommendation. I'd like to make a favorable recommendation to change the zoning of 325 James Farm Road from RS1 to RS2.
This is your area.
That's right. Talking 6 houses. 7. Clean it up.
Okay, so we have a motion for a favorable recommendation. Do I have a second?
I'll second it.
Second by Mr. Semt. Any further discussion? Hearing none, we'll take a vote. All in favor say aye. Aye. Not in favor? Mr. Watson, did you vote? You're going to abstain. Okay, so we have 3 votes in favor, 1 against, and 1 abstention. Sounds like the last vote we took. Yes.
So
Mr.
it carries. Thank you very much.
You're welcome.
And I'm sorry to be so long-winded.
1 for 2 is not
But
bad.
they keep putting these impediments in my way, you know?
1 for 2 isn't bad. You're batting 500, so take care. Thank you. Okay. Somewhere is my agenda. Who knows where it is now? That's all the text amendments, is? There is? Okay, the next one is campsite plan review, which is, there's nothing. An 824 review, the abandonment of Ornoak Place, Leslie Street, and Charlotte Street, which is off of Main Street near Ryder's Landing. We had tabled that, but didn't it pass zoning?
Well, like I said just earlier, it was an 8-24 review, so it had a time limit, 35 days. So it automatically got, approved. And the applicant has decided not to come back, even for courtesy. Not to come back because the time window lapsed, and I asked if they want to do a courtesy to the planning commission by coming back with what we requested, and they said no. The attorney said he
So
tried to
there's-
persuade, but the applicant didn't want to come back.
So there's nothing for us to do.
No, it's just got automatically done.
Okay,
But
moving
we'll
right
have-
along. It was automatic because we have 35 days. We put it on, we tabled it, 35 days have passed. The group doesn't, no, it's just 35 days have passed. So it automatically goes into effect.
But they'll still come back to the zoning commission at some point when
Zoning or planning?
zoning.
Zoning.
They do already have that, but when they go for the development design, they have to show, what we requested them was to provide a public access easement to connect to the waterfront. And they were not pretty sure about their designs right now, so they didn't want to come back. But when they come back before
Easement.
zoning, they will definitely, have to revisit that easement part of it.
Okay, so it's in our minutes
Mm-hmm.
that we would. Okay, can I steal that? If you look at our minutes, we discussed public access for pedestrians and bicycles, and retaining a portion of the property for public access easement to the waterfront, and I believe for utilities, per the engineer. Should we, since this will go to zoning, should we make a recommendation to zoning to take those into consideration?
I think, even otherwise, the town engineer is involved in this review, and the planning and zoning staff are involved, so we definitely make sure that we do have that easement in place, at least as part of our staff comments.
Would it be a stronger recommendation? If you
We
can't-
can't do anything right now because it's done deal. There is no recommendation that'll, because.
I gotta,
Yeah, Mr. Stephens.
it's more of a concern than anything else. So we sit on this commission, right? And we go through either favorable or non-favorable recommendations to zoning. And then we come back and find out, either through watching it on TV or sitting here and finding out that things are approved or not approved. So maybe, Ms. Smith, you can give us some ideas of when you were in New Haven. Should we seek power in this commission to be able to approve something or not approve something and not have it go to zoning and then have us, look, almost look like, we really don't care what you guys recommend or don't recommend.
Yeah, that's the problem, and that's why most communities like New Haven have a combined commission of planning and zoning. So
So-
they do look at, the planning side of things, but then they also relate them more to their zoning applications when they're voting on them. In this case, we have two separate bodies, and typically planning commissions are by statute, looking at the big picture, their recommendation or advisory in nature. But the zoning is where the development review actually happens. And that's how these commissions' powers and authorities have been set up through the state statute. So there's very little that we can do unless the town council decides to combine both for more efficiency.
Yeah, it's just very frustrating that we sit
But at
here
the
and
same
then,
time, what I found to be most useful having a separate planning commission than having a combined commission is the amount of time you can devote to plans, actually. Because now you're not sitting until midnight trying to review development applications, as well as think about the complete streets, greenway plans, and other plans that we're talking about. But one thing we could do to make it more efficient is request the zoning commission to send us a letter on what was voted on, in which way, and what the reasoning was. So we're most, at least it'll keep us more informed on, on what basis they're voting these things.
Although it's after the fact. Is there any way of, the 35 days, is that state statute?
Yes, state statute. And I found that the way, like Mr. Knott presented earlier, it feels very threatening sometimes, saying, if you don't do this, you'll lose millions of dollars of commercial property investment. If you don't do this, you'll get an affordable housing developer in this parcel. And it's just bad business. Just do your business right. Give me your stuff beforehand. I will review it, and I'll bring you my best judgment based on what I learned in the field, just like how you have learned. And that's what I think we as a commission should focus more on, making sure that applicants are not bringing last-minute stuff. Exhibits changing in the last minute and asking us to vote on these things is not a good practice.
I don't think that really answers Dan's question about, it's like we have.
Yeah, unfortunately, and I think we all feel the same frustration, but it's state statute that we're dealing with, not, it's not like we could go to the town council and ask them to change a town statute or ordinance, because it's not town ordinance, it's a state. So unless you go to one of your legislators, on the state level, it's not going to change, yeah.
So if you went to the state and said, listen, we want to combine,
Well,
No, you have to vote on
that is,
that.
I think, the town charter that you would change.
Yeah.
For combine. I apologize, I don't mean to deviate from the topic, but these two are very related, even though they look unrelated.
Yeah.
Because the 35-day window is by state statute given in such a way that we get a complete application in that 35-day window, and we would have had time to review it and comment on it. There's a reason 35 days is a lot if you get everything beforehand. But if you get everything on the day of the hearing, then, it doesn't make
Yeah.
any sense. And that's why I'm telling you, even if you had 35 days, the way you can make it more efficient is by requesting applicants not to submit exhibits in the last minute unless it is really, really necessary, and otherwise just encouraging them to bring it beforehand.
Well, I agree with you, and I think, I know for me, that had something to do with why I voted against the Ertstadt Biddle properties, not for anything other than I don't agree with the process that was used. And I don't want to set a precedent, people watching this and saying, well, we can go before them at the last minute and, they're not going to even listen to the staff comments.
And
It's
we
not
are
right.
not required by statute to provide staff comments. It's just a courtesy that the staff does to the applicant. We are required to offer our staff comments to the commission to make a decision, but we are not required to provide our comments to the applicant. But they are required to provide us everything that we need to review and critique the application in that 34-day window.
Yeah. Yeah, I think it was a little bit unfair of attorney not to bring that information at the last minute. But anyway, anything else? Otherwise, moving right along. There's no discussion on the section 5.3 zoning regulations. 6, nothing on erosion and sediment, nothing on bond. Oh, no,
We do
there is
have
a bond
bond
release.
So the town engineer has cleared this property for a bond release. All work has been completed per what was agreed upon. And the exact amount to be released for the subdivision bond is $142,812.50, which was posted way back before the subdivision process began. So I request the commission to release this bond for the applicant.
Questions, comments? Otherwise, can I have a motion to release the bond in the amount of $142,812.50? Did I say that right?
Yes.
I would like to make a motion to release the bond for 93 Ward Street in the amount of $142,812.50.
Thank you. Can I have a second? Mr. Watson? Any further discussion? Hearing none, all in favor say aye. Aye. Any nays? Passed unanimously. Cool. Okay, there's really nothing on the Greenway project other than I have a letter that will be sent to Linda Pepin, the chairperson of the Greenway Subcommittee, asking her and the Greenway Committee to come to our next meeting, which is Tuesday, November 19th at 7:30, to discuss the future of the Greenway and their next steps, as well as informing them that Harold Watson and John Staley are, as we voted at our last meeting, are full members of the Greenway Committee, and that Susmitha
Atota.
yeah, that. I'm sorry, it's late. Town planner is an ex officio on the Greenway Committee, and that you should all receive agenda minutes, cancellation notices, and any other correspondences. Yeah, just to give us time to get to that on the agenda. That's all. Well, sometimes we have special meeting, so I don't know there's going to be a special meeting. You're right, on the 19th. No, our meeting starts at 7. They're coming at 7:30. If we have a special meeting, then we'll be okay, because it'll be, not a special meeting, a public hearing. If we have a public hearing, that would be at 7 o'clock. And then this would be at 7:30, and it would give us time to get through quite a bit of the agenda, even if we don't have a public hearing. So I just wanted to let you know, because we talked about sending this, and I was going to invite them to the October meeting, but then we changed the October meeting, so I changed it now to the November meeting. Okay? And I will sign that. Nothing on complete streets.
I know that they're doing preliminary work on the Elm Street portion. They're doing surveying and prepping materials. I also know that this week there was a whole citizens group that surrounded a tree. I know that when we were working on the Elm Street portion, we identified several specimen trees that were not going to be taken down, that the pathway actually goes around them. And so we actually invested the extra money to save those trees. I just would like to see someone confirm that those trees are still there and that someone like UI is not in there messing them up, because this group seems to be very volatile in protecting their trees.
I can certainly convey this to John Casey, town engineer, and check.
Can you do that? 'Cause
Yes, and I'll
it
get
would
back to you.
head off losing those trees, but also maybe they need to know that we are specifically trying to save them.
Okay, there's nothing listed under coastal resiliency plan. And on number 9, other items, we have,
May I ask, to Smith, another question on terms of coastal resiliency? You were meeting with FEMA. Has that occurred yet?
Yes, we did have a meeting
And their
with,
response?
we are going to get our grant on the water pollution control. Yes.
excellent.
That's applause, everybody.
Yes.
Should have been here.
Good.
Great news.
Are they going to do the
All
whole
right.
thing, or are they just doing something
Well,
interim?
we requested 2.5 million, so we're going to get that.
Oh,
And
great.
Do the whole thing?
But that doesn't, only 2.5 million doesn't suffice it. We need to match it with additional bond money. And they said when the next funding stream opens next year, they will reappropriate the funds towards this. And so we'll get a confirmation letter sometime next year.
So hope no hurricanes in the meantime, and we'll be okay. Thank you.
We're almost through this season, so. Okay, does anybody want to take the text amendment off the table?
This is special meeting, so we
We
just
can't
have to, continue.
Leave it? Okay. No updates on the MetroCog bike share, no updates on discussion of the Shakespeare Theater. We've sent our recommendation on Shakespeare property. Is that something we can take off the agenda now?
Yeah, but I still kept it because we still haven't presented it before RDA, and I wanted to give you an update on what happened there
Okay,
once
Once
it's
it
presented
happens.
there.
okay. Mr. Staley, you had your hand up.
A quick question. Is there a summary of everything that went on with the public meetings and
For Shakespeare?
for Shakespeare?
Oh, there is a whole PowerPoint online under the Shakespeare Property Visioning page. I will send you a link to that.
Okay, thank
yeah.
you.
Okay. Number 10, member comments and concerns. Anybody have anything they want to discuss? How can you do that with a special meeting? You can't. Never mind. Can't do that. Okay, can I have a motion to adjourn? Mr. Senft?
So moved.
Second. All in favor?
Aye.
Anybody opposed?
Thank
Great job, you guys.